Okay. Yep, I'm there. Okay, good. Welcome all. Good day, wherever you're dialing in. Welcome to the second session of Legal and Commercial Perspectives, which is jointly hosted by SCMA and ICS Singapore branch. It's definitely a great initiative started by Punit and has generated a fair amount of interest. We have a total of over close to 190 sign-ups today, and it presents the commercial perspective to a legal case, which can be very divergent at times. So we definitely look forward to this series, which we would like to host about every quarter or between a quarter and every half yearly. So with that, I would like to pass the mic to Ms. Tan Beng Tee, who will do her opening remarks. Ms. Tan Beng Tee is the chair of the Singapore Maritime Foundation, and also very importantly, an honorary fellow of our institute. So we are proud to have her as a fellow. Over to you, Beng Tee.
Thanks, Captain Dat. Captain Dat, Punit, distinguished panelists, and ladies and gentlemen, a very good afternoon to all of you. First of all, I would like to thank ICS and SCMA for organizing this important platform to create actionable knowledge sharing. In fact, I was so fascinated by the words because the words are actually very visual and very clear about knowledge sharing, and most of all, it must be actionable. So last November, when I first joined this series, I spoke in my capacity as Assistant Chief Executive of MPA. I was then covering industry development as well as talents development. Many of you would actually know MPA. This time round, I'm actually addressing you as Executive Director of Singapore Maritime Foundation. And I hope that over time, all of you will know much more about SMF. Maybe just one key salient point about SMF. SMF is actually created to coordinate and to nurture strong cooperation between the government, industry association, as well as maritime companies. Our objective is actually to grow the maritime ecosystem, for which the legal and maritime services, maritime arbitration services are part of this. And most importantly, we also like to grow the pool of talent that is actually critical for the maritime ecosystem. In fact, when you look at Singapore, the only natural resources that we have would be our people. And that's why there's also a lot of emphasis to growing the resources on people. Just a couple of days ago, I was just rereading some of these publications, one of which was actually done by Menon. Menon as well as DNV actually published a report known as the leading maritime capitals of the world. And in that report, they actually rank the countries on various aspects. So when I was actually reading it, there was one particular line that actually kind of appealed to me. In the report, Menon and DNVGL actually highlighted that while shipping has been an international industry and for a long time, because all of us know that shipping is a global industry, maritime services, however, they said, until the last decade has been relatively national or regional, and is always located around ship-owning companies. And then the report further said about something about ship financing as well as legal, for the legal aspects. On ship financing, they said that ship financing was amongst the first to globalize, but for legal services, due to national jurisdictions, it has always been much more national. But I'm glad that over time, this has changed. In fact, I think for legal services, there's a lot of cross-boundary kind of transactions which needs the legal services. The Singapore Chamber of Maritime Arbitration was reconstituted in 2009, partly because we wanted to actually have an arbitration center that is able to cater to the needs of the maritime community. So SCMA was reconstituted in 2009 to actually give the industry more options. The option of doing unadministered arbitration or ad hoc arbitration, because this would be one form of arbitration that resonates well with the maritime community. I'm glad to also note that over time, Singapore's continued growth as an international maritime center. We've got more than 160 international groups that are based in Singapore now. And because we've actually grown the pool of ship owners, operators, as well as the maritime community, including the trading community, we find that SCMA has also gained recognition as the place to turn to for maritime arbitration. So with the objective of serving the industry better, SCMA has embarked on two key tracks, I would say. One is to leverage on its location as in the most dynamic and economically vibrant region in the world today. Two is to actually ride on its ability to effectively be a cultural bridge to bring value between the East and West, especially now when there's much more transactions that are actually done in Asia, and much more European companies are actually now in Asia as well. So in this regard, both SCMA as well as SMF has also been looking at how can we actually promote recognition of Singapore's arbitration. And we actually work on default choices with PIMCO, and Singapore is now one of the 4 default choices for PIMCO's law and arbitration clauses. Yeah. So in a way, it is good for Singapore because it is a recognition that Singapore would be also a good place for arbitration. Now I'd just like to say something about ICS. ICS is another important key player, and having been in Singapore since 1978, so I was just calculating, it is a good 43 years. And over this time, ICS has done fantastic work in raising the professional qualifications of commercial shipping and shipbroking courses, which I believe are now globally recognized. And over the last 3 decades, ICS has not only grown in terms of its membership, but has also grown in terms of its stature as an expert in commercial shipping and shipbroking. I would also like to add that ICS, SCMA, and SMF share a common interest in providing a skilled pool of talent to the maritime industry. To realize the shared interest against a larger context of an industry which is actually now undergoing transformation, and transformation in a much more complex world, we will actually need greater cooperation and greater collaboration amongst all stakeholders to ensure that we continue to develop future-ready skills in the tertiary institution and to raise standards amongst the professionals. The second, legal and commercial perspectives, is an excellent platform to achieve both objectives. So in this regard, I'm very happy to also note that besides legal and commercial professionals from the industry, this session is also open to law professors as well as the students from the universities. Here, I would just like to conclude my just short remarks by thanking the esteemed colleagues from law firms and shipping companies who are generously contributing their time to present holistic insights into recently decided maritime cases in Singapore and England from both legal as well as commercial perspectives. I wish all of you a fruitful afternoon. Thank you.
Yeah, thank you, Bengti, and especially thank you for the kind words for the institute. When you were at the MPA, and even now our relationship will continue, and your valuable support. So with that, let's kick off. We have a very exciting afternoon ahead. We have 6 speakers on the panel. 3 of them are the representing the law firms which handle the particular cases, and the other 3 panelists are from the ICS. I'm particularly happy, and I keep patting myself on the back for presenting them. So all 3 are, to begin with, all 3 are ladies, so they represent, they underscore the feminine representation in Singapore shipping. So that's a great point. And of course, all 3 of them are members of the Singapore branch, ICS members. And lastly, all 3 of them are hands-on chartering people, so their perspective couldn't be more commercial. They are doing day-to-day chartering, and they bring that experience to the table. So I'll talk a bit about the, I'll present the 6 persons, talk a bit about the CV. But before that, the 3 cases are basically, the case 1 is Noble Chartering versus Pre-Mines. Case 2 is China Coal Solution versus Avra. And the 3rd case is Regal Seas Maritime versus Oldendorf. And the respective panelists would talk about it as we go along. So introducing the 3, I'll start off with the legal experts, panelists. So first one is, excuse me, Mr. Paul Ashton from Holman Fenwick Quillan, HFW. He has had considerable experience as a dispute resolution lawyer and a project lawyer in several cases, and had significant international arbitration experience as a fellow of the Chartered Institute of Arbitrators. He has acted for parties in international arbitration and mediation in many jurisdictions. Also been appointed by Singapore Mediation Center as one of the associated mediators, and the fellow of Bali International Arbitration and Mediation Center. Paul sat for 4 years as a board member of the SCMA. He's also qualified solicitor and High Court judge of England and Wales, Court of Hong Kong, and a registered practicing foreign lawyer in Singapore. In addition, I also like to thank Holman Fenwick, who have been a regular supporter for the Institute's prize giving award ceremony. So thank you, Paul, for that. The next legal expert is Mr. Joseph Tan, who is managing director of JLX LLC, and also a panel arbitrator on SCMA. He specializes in commercial dispute resolution, particularly in the field of shipping and international trade. On top of an active practice in litigation and international arbitration as counsel, Joseph regularly receives arbitrator appointments for shipping and international trade disputes. Joseph was recommended by Legal 500 Asia Pacific for his work in shipping litigation, and clients have commented for his understanding of maritime cases in Singapore and other jurisdictions. The third legal expert is Mr. Stephen Pedersen. He's a partner in Pennington's Manchester Cooper, Singapore, and also a panel arbitrator with SCMA. He's a partner in Pennington's Manchester Cooper, and main focus is arbitration and mediation. And he regularly acts on SCMA, LMA, SIAC, and Hong Kong International Arbitration Center. He's been based in East and Southeast Asia throughout his career, and has extensive experience and understanding of both regions and local cultures. And he speaks 5 languages, including Danish and Mandarin. So that almost circles the whole globe, He was admitted as a solicitor in Hong Kong and England and Wales, and is also licensed to advise on Nauru, Niue, Tuvalu, and Kiribati. These, of course, the various flags which are not as well known as the Singapore flag, I guess. Now we move on to the commercial panelists, whom I was mentioned earlier, all ladies and all members of our institute. Again, in no order of priority, there's Lakshmi Priya. She's chartering manager with Norvik Shipping International. Very interesting background. She's a marine engineer and a sailor. That's how she started her career, and now experience in technical and commercial management. She worked across tanker, container, and dry bulk sector, and now she's the chartering manager in Norvik Shipping International. So in her current position, she's primarily responsible for maintaining cargo book of the team in line with the freight market, and tends to create value from arbitrage and positioning of vessels in the freight market, and negotiate charter party terms to ensure that company is not exposed to open-ended liabilities, and also risk the company is insured against. Next is Ms. Anupama Chauhan Gupta. She was vice president Vasi Shipping, and now the Chief Operating Officer at Netbulk. Here again, she had a very interesting start to her career with a short service in the Indian Navy, and from there on, she moved on to the commercial world, handling various commercial roles in the dry bulk chartering arena. So before joining this company, she was vice president shipping at Vasi Shipping, heading the dry bulk division for almost 7 years. And of course, she's a fellow of the Institute of Chartered Shipbrokers. The third panelist is Elaine Nui. She is the freight trader chartering at NG, which is an energy trading group. She's a member of SCMA, fellow of the Singapore Institute of Arbitrators, member LMAA, and of course a fellow of the Institute of Chartered Shipbrokers. And she's also a tutor for our branch. She had more than 14 years in commercial shipping, and currently she works as a freight trader in NG. And prior to that, she was with Norden, holding the position of operation manager, which again underscores the point that ladies can handle the responsibilities of a typically male-dominated job in operations. So with that, I have introduced the panel, and I look forward to an exciting ride. So fasten your seat belts, and we look forward to the next presentation, which, let me see, which will be Noble Chartering versus Premines, and that will be presented by the legal expert, Mr. Stefan Pedersen. Over to you, Stefan.
Thank you very much, Captain Dutt. Can you hear me?
Yes, we can, Stefan. Yeah.
Okay, you can see my screen. I've shared my screen.
Yes, we can.
Okay, thank you. All right, we only have 10 minutes, so I'm going to kick off. The Thai prize involved a very standard charter party chain. You had head owners time chartering their vessel out to disponent owners, who were Noble, and Noble in turn voyage chartered it out to Primins. Okay, and the voyage in question was from Brazil to China with soybeans. Some of those soybeans had suffered from silo burn, which is pre-shipment damage in the silos in the load port. That damage was not obvious, but it would have been discoverable to the shippers by reasonable means, but was not discoverable by the master or the crew during loading. And in fact, of course, in this case, the master did not discover it. And those were the findings of fact as to the damage, silo burn to the soybeans before shipment found by the arbitrator. And that's very important because those facts bound the court in this case. So what happened? Well, the shippers, after loading was completed, presented a draft bill of lading to the master in the normal course. In the description of cargo part of the draft bill of lading, they had typed in the words "clean on board," and the bill of lading also contained the standard printed words in the congen bill form, shipped in apparent good order and condition. The master had a look at the cargo, and it was there. The bill of lading was then signed off without reservation. The ship sailed for China, and upon discharge in Guangzhou in China, damage was found. What then happens is what normally happens. The receivers decided to pursue the owners in the Chinese courts. And what normally happened is that the Chinese receivers won, and they got an award for about $1.08 million in damages against the head owners. The head owners paid. The head owners then turned around to Noble and said, look, guys, you have to pay us 50% contribution under the ICA in the time charter. Instead of contesting that claim, and this is very important, Noble decided to settle it for $500,000, and then turned around to the voyage charterers, Primins, in turn, asking for an indemnity to cover their losses. In the arbitration between Primins and Noble, the arbitrator found that whilst there was no express warranty or indemnity in the voyage charter allowing the disponent owners, Noble, to get an indemnity from the charterers were nevertheless liable to disponent owners because she held the shipper was the charterer's agent, and so the charterer she held had warranted the accuracy of statements made by the shipper in the draft bill of lading presented, and had impliedly agreed to indemnify the disponent owners against any inaccuracies in those statements made in the bill of lading by the shipper. The arbitrator said that if it were otherwise, if there was no implied indemnity or no warranty, then the disponent owners would have no recourse at all for any wrongs of people which were on the charterer's side of the line, as she called it, which the shippers were, because they were the charterer's agent. Accordingly, the arbitrator found the charterers had warranted that the cargo was in apparent good order and condition when the shipper handed the master the draft bill of lading to that effect. However, the arbitrator found the cargo was not actually in apparent good order and condition, and the shipper had reasonable means to discover its condition, as she found, as we've mentioned earlier. Accordingly, she held the charterers had to indemnify the disponent's owners under the indemnity which the arbitrator found was to be implied. Well, the charterers didn't like that. They thought it was wrong in law, so they appealed on a point of law to the Court of First Instance in London. And the court was invited to decide 3 questions of law. Firstly, it was invited to decide whether or not the words "clean on board" or "shipped in apparent good order and condition" in the draft bill of lading whether those words were a representation and or warranty by the shipper as to the cargo condition, or whether they were merely an invitation from the shipper to the master to go and make a representation as to the apparent condition of the cargo based on his own assessment of the cargo as loaded. The second question the court was asked to decide was whether the words were if the words were a representation or warranty, whether any statement in the bill of lading in this case actually made was actually an inaccurate statement as a matter of law. And thirdly, if it was an inaccurate statement as a matter of law, whether the charterers then had to indemnify the disponent owners for such inaccuracy. Well, the High Court judge held in favor of the voyage charterers, and he decided the first question that the presentation by a shipper of a draft bill of lading with wording as to shipped in apparent good order and condition was simply an invitation only. The master had to make his own independent assessment of the apparent condition of the cargo and state that in the bill of lading. That statement was very important. It was a statement from the master on behalf of the ship owner to the shipper as to what the state of the cargo apparently was when loaded. And that statement could be relied upon by the shipper and by subsequent holders of the bills of lading. Accordingly, it was a statement the master had to make and not a statement the shipper had to make. As to the second question, as the master in this case had inspected the cargo and found that it was apparently in good order and condition, the judge held that there was nothing inaccurate on the face of the bill of lading. Right? It stated exactly what the master had found, that the cargo was shipped in apparent good order and condition. And as such, on the basis of that finding, there could be no indemnity triggered at all, even if there was an indemnity, because there was no inaccuracy in the bill of lading presented. Now that finding made the third question, whether there was an indemnity, rather academic. But still, the judge had to go and opine on it, and he held that there was no space or scope in this case to imply an indemnity in favor of the disponent owners. And this was because, first of all, it wasn't necessary to imply it for the contract to work, or nor was it so obvious as to go without saying, which are requirements for implying terms under English law. And in addition, he mentioned the Hague rules, which applied in this case as well to the charter party. And the Hague rules deliberately do not give an indemnity for any statements as to the apparent condition of the cargo, because they are statements made by the master. And he decided that because the Hague rules didn't deal with this, it must mean that there was no room, or there was no intention for there to be an indemnity for this in favor of the ship owner, and therefore it would be wrong, and there would be no room to imply an indemnity in this case. Accordingly, he held that the arbitrator had made an error in law. He also stated, interestingly, that the disponent owner's loss in this case was because it had decided by itself to pay the head owner's loss. It settled the claim, whereas what it should have done was to query its own liability, challenge its own liability on the basis that the damage was pre-shipment damage, and thereby not have any liability incurred. Now, the disponent owners didn't like that result, so they appealed to the Court of Appeal, and they brought much the same arguments as before. They said in respect of the first point that the judge had erred because the presentation of the draft bill of lading was, they said, both an invitation to the master to go and make an assessment of the apparent good order and condition of the cargo, but it was also a representation by the shipper at the same time. Secondly, they said the bill of lading was inaccurate here because the cargo would have been found not in good order had the shipper made a reasonable inspection of it. Thirdly, they argued again that there was an indemnity, and they relied on a few old English cases, three of which I have listed here. Finally, the barrister for the owners made a cri de coeur, a cry from the heart, saying that it would be unfair in this case if disponent owners were left without any recourse when their liability from damaged cargo arose from damaged cargo which shippers who were, as we have seen, on the charterer's side of the line could reasonably have discovered was damaged, but the master could not. They said this would simply be an encouragement to shippers to misdescribe the cargo in draft bills of lading. Well, the Court of Appeal upheld the judgment at first instance. Firstly, it confirmed that the presentation of the draft bill of lading was only an invitation for the master to make his own assessment as to the apparent condition of the cargo, not the actual condition of the cargo, just apparent as it was to him. It confirmed also that the bill of lading was not inaccurate in law. And the reason for that was that the statement as to the apparent good order and condition in a bill of lading is a statement from the master to the shipper. It has to reflect what the master thinks the apparent good order and condition of the cargo is. It refers only to the external condition of the cargo, apparent so far as meets the eye of the master on a reasonable examination. And it does not refer to the actual condition of the cargo, as I have said. Accordingly, given it's the master's view of what the apparent condition of the cargo is, the shipper's knowledge of the state of the cargo has absolutely nothing to do with a statement in a bill of lading as to the apparent good order and condition of that cargo. In this case, as the bill reflected what the master had found on a reasonable examination, it was not inaccurate. Thirdly, with respect to the indemnity, I apologize, he found the judge went very carefully through all the authorities cited in favor of the implied indemnity, and he held that none of them related specifically to implying an indemnity for the description of the apparent condition of the cargo, and so they were no help to Noble in this case. In relation to the cri de coeur, and this is very interesting, the Lord Justice expressed sympathy, great sympathy with the argument that if charterers and shippers had actual knowledge of cargo damage, then they should not be able to escape liability in this situation. However, as there was no finding in this case by the arbitrator, as we saw at the very beginning, that the shippers had actual knowledge, she just found that the shippers could have found out, not that they did, then he did not have to decide this at this case, but left it open to be decided in the future. So a brief run through of points to note of the Thai prize case. First of all, it affirms the position on apparent good order and condition in bills of lading, as it has always been. It's a statement by the master, and there is no charterer's indemnity given to the ship owner in respect of that statement. Furthermore, as I've said, the court was bound by the facts as found by the arbitrator and limited by the arguments brought in the arbitration. So it is still possible for different solutions on different facts to come about. So it's possible, for example, for an indemnity to arrive if the tendering of the bill of lading is a request to sign the bill of lading without an inspection, for example. If you say to the master, don't bother with the inspection, just sign this, there may be an indemnity. In addition, very importantly, the shipper's typed words, clean on board, were not argued before the arbitrator as being a representation. Now, it might have been different if that had been argued, because then that could have been argued on appeal about whether or not that constitute a representation. The first instance judge did say that in his view, this would have been a representation, but he couldn't decide anything on it as it hadn't been argued before the arbitrator. As we have seen, the Lord Justice Males left it open for the possibility that a shipper with actual knowledge might be deemed to make an implied representation. And lastly, the important point to note is you should bring all arguments in arbitration so that they are available to you on appeal. And secondly, you shouldn't settle claims too quickly. Go and talk to your lawyer. Make sure you fight your claim properly. And very lastly, will there be a further appeal? Well, the Court of Appeal denied permission to appeal, but the Noble has applied to the Supreme Court for permission, and that application is still outstanding. So they might get permission, so watch this space. And that's all from me.
Thank you, Stephen. I think you managed the time very well. Thanks. Yeah, so we will pass on to then Lakshmi to give the very practical and commercial perspective. Over to you, Lakshmi.
Thank you, Captain. Hi, Stephen. Stephen did a wonderful job of explaining the legal aspects of the case, and also cited previous cases where similar cases where the BLs have been. The importance of BLs and the clean on board. First and foremost, if we see shipping, the contractual matrix in international shipping is quite complex in nature. There could be multiple sale and purchase contracts between the buyers and the sellers. And there are likely to be multiple players in the supply chain. And one of these parties in the chain will then will be responsible for a contract of carriage, and now that initiates another contract, another chain of head owners and disponent owners, sub-charterers and charterers. So all these parties together in all govern the trade in good faith. And when there are so many parties involved, not all contracts, all clauses, everything may be back to back. And there will be some exposure, a risk exposure to different parties, depending on what contracts that they have agreed upon and signed for. And let's start like what happens during the loading process and how the process is, how the cargo is moved from point A to B now. Now at the loading port, a shipper is nowhere near the cargo. He may or may not have access to the cargo. He has not even seen the cargo. Now, when the sale and purchase contract is initiated, and they appoint a cargo surveyor who then inspects the cargo to check to verify the cargo quality prior to loading on board. He is the first line of defense for a receiver that his cargo is being inspected, is in good condition. Now, the second line of defense is the master himself, the ship staff, who are expected to inspect or not inspect, or to keep an eye on the loading, to visually check the cargo is in apparent good order or condition. It is beyond the job of a master to check for or to inspect the quality of the cargo. But as to what meets the eye, does the cargo look good in apparent order. Now, some companies do have a ship captain or a port captain who is additionally there to inspect just the cargo operations, and who also has certain remarks about the cargo, how it's to be loaded, to protect different parties' interests. And now during the loading, the cargo surveyor, the master of the ship, and if appointed, a port captain, so they all ascertain the quality of the cargo or the cargo that is being loaded. And if at the time of loading they do spot something that is not in line with the cargo, the cargo is the condition of the cargo is not good, the cargo is decolorized, the cargo is smelly, they have to raise a flag right then and right away. From a commercial perspective, it is best to stop loading at that point, inform all the parties in the line, the shippers, the receivers. They need to be aware that the cargo that we are loading at this point is not sound. And before loading the cargo, now the quality of the cargo needs to be ascertained. Now, this could lead to some delays at the load port. The ship is waiting for some time, and the bad cargo or the cargo that is not good, which is loaded now, that's being discharged, replaced with good cargo. There's some cargo quantity differences. So all these things come apart, but that is a good line of defense, both for the ship as well, and also for the receivers, to reject the cargo right there itself when it's not found to be in good order. Now the cargo is in good order and master has proceeded to sign the bills of lading. Now he is responsible for delivering or discharging the cargo as per the bills of lading at the discharge port. Now, in case like soybean or cargo like this, where the inherent vice of the cargo also plays a role. The moisture content of soybean is like at particular temperatures that it could develop mold formation, like when the voyage is processed, or when it looked apparent at the time of loading, but while sailing the cargo is damaged due to inherent moisture in the cargo itself. Then how does owner protect himself? So at the discharge port, the vessel has arrived, the holes are open, the master is discharging the cargo, and now he finds that some part of the cargo is not as per what he has loaded, or is defective. Now, of course, the receivers are not going to be very happy with this. They're going to reject the cargo. At first instance, the risks of the people involved here, and the party who has the bills of lading, and the risk of the person who's there. So this is quite high. Now, it may be possible that the receiver does totally rejecting the cargo, and you may even threaten to arrest the cargo. Now, depending on the discharge port and the legal system, sometimes the ship owner and the P&I club may have no other option but to agree for the cargo claim as presented by the receivers. Now, it takes time to ascertain like when the cargo was damaged or how the cargo was damaged. You may take some samples, you can send them out for inspections, and all these steps, they take some time. So at the first instance, the ship owners have no defense there. So they may be forced to discharge the cargo and accept the claim. So commercially, what one can do is to keep the doors open, initiate talks, negotiate with the parties, try to reduce the risks and also the losses for each other, and try to settle it amicably between the parties. But sometimes that is not always feasible. And then it goes into mediation, resolution, dispute resolution, arbitration, and court cases, and and then the lawyers take over. Now, coming to the points raised in this particular case, if you see under the time charter party, I mean, you can say that there usually is an express or an implied warranty that when the ship owners follow the instructions of the time charters, they are indemnified. But the same indemnity is not there in a voyage charter party. A voyage charter does not indemnify the owners for following the instructions, for loading as per the instructions. So well, you may try to have some kind of a wording or a clause with the voyage charter parties to say, okay, to cover your losses or to protect yourself, but it is not very practical, and it is not industry practice to have that
Lakshmi,
kind
you're
of
reaching your time limit.
Oh, okay. So this case is quite what to say, quite clearly says about the bills of lading in the first, and the secondly, like how owners should be prudent in their loading aspects, and this to avoid a claim in the first place itself, than to have to deal with their exposures there. Yeah. Thank you, Captain.
Hey, thank you, Lakshmi. Yes, I think you did present the commercial perspective very well, and which is what most of us on the commercial side or seafaring side would look at. I mean, for the ship, if the holds are tight, staunch, and strong, watertight, and if there is, in the case of soybean, there's no ventilation, if that is done between the ship moving from a very wide range of temperatures during the voyage, I think the carrier has done its duty, and inherent damage to cargo is not something which the master would be expected to see. You know, so that's definitely that's the responsibility of the carrier. We probably might see more of it. We are seeing a lot of ships now with grain, wheat going into China and having prolonged anchorage. You know, so with this delay, you might see more cases of cargo damage when the ships eventually berth to discharge, and it'll be interesting how receivers and P&I clubs, etc., deal with it. We don't have too many time for questions, but we'll open it up to the public if there are immediate questions, or else move to the next case and then do the questions at the very end. I don't see any questions here, so that's good. And if any of you have any questions later amongst the audience, please, we could handle it at the end. So with that, we'll move to case number 2, which is China Coal Solutions versus Avra, and presenting the legal side is Mr. Joseph Tan. So Joseph, over to you.
Yes, can you all hear me?
Yes. Yeah, okay.
Okay, very good. I think I will start by sharing my screen. Okay, am I sharing the screen now? I can't quite see it here.
Yep, we can see your screen.
It's good, yeah, it's good.
Okay, very good. Yes, good afternoon, everyone. Today, I'm going to talk about this case of China Coal Solutions versus Avra Commodities. It is not a shipping case. It's a case for the sale of 3 shipments of coal on FOB terms. The case is deceptively simple. It relates to the issue of when is a contract legally binding. And for a case which is deceptively simple, a large number of these cases do end up both in court and in arbitration. Okay, I know a number of you here are lawyers and are legally trained, and this is basically contract 101. For a contract to be legally binding, you need to have all these 4 elements: offer, acceptance, consideration, and an intention to create legal relations. There are times when parties wish to defer the formation of a contract to a later stage. For example, when they say in their negotiations, in the offer and acceptance, that any acceptance is subject to contract. If that is the case, if there's a subject to contract provision, whether is it expressly or by to be inferred from the conduct, then the contract is not formed until both parties sign on the contract. Now, coming back to the topic, the facts of this China Coal Solution case, how it works between them, they are both commodity traders trading in coal. How it works between them is between the traders, they will, first of all, the sellers will send an email setting out the main terms of the contract. After that, the buyer will start negotiating on the main terms, usually on the price, the laycan, if there's any demurrage provisions, etc. After the main terms are concluded, there will be one email from the buyer to say, fine, we accept all the terms as set out in the main terms. When that is done, the seller will send what they call the business confirmation email, where they will attach a draft formal written contract, which is invariably on the seller's standard terms. And I pause to flag this because this is a point which will be important later on in the case, that the draft formal contract is on the seller's standard term wording. After the standard terms were sent over to the buyers and sellers started negotiating via email on the various clauses in the standard term contract. And after a few weeks, there were several proposals by the buyers to make certain amendments, for example, like the LC clauses and all that. But the sellers will say, no, you cannot change any of the standard terms. We insist you must comply with our standard terms. They only accepted one tiny amendment to one of the clauses, which is quite immaterial. Eventually, after a few weeks, the buyers sent an email to the sellers saying, fine, we accept all the terms in this draft standard term contract. When the buyer finally accepted the standard term contract, the seller signed on it and sent a copy by email to the buyer. Sorry. And this is where I pause to mark another point. After the sellers sent it over to the buyers did not sign it and send it back to the seller. And for reasons which were not elaborated, the buyer changed their mind after that, and they decided not to proceed with this transaction. And when the buyers didn't proceed with the transaction, they didn't sign the contract, the sellers kept coming back saying, hey, hello, you have agreed on the terms. Please sign the contract and return it to us. The buyers just didn't respond. Eventually, the seller started instructing lawyers and sending demand letters and terminated the contract on the basis of the buyer's repudiatory breach. It was only at this point that the buyers replied to say, I'm sorry, but we do not think there was a legally binding contract between us because why? I didn't sign the contract. The sellers didn't accept that, and they commenced proceedings in the Singapore High Court. The point which was relied upon by the buyers is this clause 26 in the standard form contract, where it says that this agreement shall only come into force after being signed by both the buyer and the seller. And this is where conceptually there's a bit of a conundrum, because in the email exchanges, which they call the business confirmation emails, there was no indication that this was subject to contract. There was no indication that the parties intended to defer their legally binding nature of this contract till after it is signed. And this clause only appears in the standard term contract after the business confirmation emails were sent. So the seller's position is, we do not agree. Since the business confirmation emails were there, and since there's no subject to contract, you are legally bound based on the email exchange. The buyer's position is, I'm sorry, but we agreed on your standard term, and this is part of your standard term, which says that it will not be legally binding until it is signed by both buyer and the seller. When the Court of Appeal, well, it went first to the High Court when the High Court agreed with the seller's position and said that there was a legally binding contract based on the email exchange alone. TCS was not happy with the decision, and we appealed to the Court of Appeal. And in the Court of Appeal, as I mentioned, there are some facts which is very important. First of all, this is not the first time the parties have transacted with each other. There were altogether 4 transactions. The first transaction happened in 2015, September 2015, where similarly, there was this exchange of emails, business confirmation emails were sent. The draft standard term contract was sent by the seller to the buyer. But this time around, the seller didn't sign. So the buyer was saying that, look, you are legally bound, but the seller said, I'm sorry, I didn't sign. And the sellers didn't perform. Although the buyer sent notices to protest that the sellers failed to perform the contract, the buyers did not take any legal action on the first transaction. Subsequently, there were 2 other transactions, one in July 2016 and one in March 2016, where, sorry, yes, it should be 2017, March 2017. Second and third transactions, these were performed. The contracts were signed by both parties, no problem, everything was completed. The transaction which went to court is the 4th transaction, which was 29th March 2017. Pardon the typo error there. The 4th transaction, this is where the seller signed it, but the buyers didn't sign it, and this is the one that went to court. The Court of Appeal noted that this is the series of transactions between the parties, and in all 4 transactions, what was important is all 4 transactions were based on the seller's standard terms. They did not deviate from any of these standard terms. The court noted also that in the first transaction, the sellers didn't sign it, and they seem to have just treated it as while it's not conclusive, but the court took cognizance that the sellers didn't perform the first transaction, and it should not be fair for them to then turn around and say that they should not be bound now, when in the first instance, they didn't sign it and they didn't perform. So the other point which the court took into cognizance is that when the parties were negotiating on all these transactions, and this is very clearly borne out from the evidence of both sides. Both sides agree that yes, when we were negotiating on email and when we were talking over the phone, at all times, the common intention is that we will contract on the seller's standard terms. So the Court of Appeal held that in this basis, the seller cannot approbate and reprobate. You cannot, on the one hand, insist that the buyer accepts your standard terms, and yet you try to carve out clause 26 when it's not in your favor. And on that basis, the Court of Appeal held that this case, the evidence showed that the parties, when they enter into that business confirmation emails, they did not intend for that series of emails to be legally binding, because all along the intention was we will contract based on the standard clauses, which provides that it has to be signed by both parties. And on that basis, the Court of Appeal held that there was no intention to create a legal relationship based purely on the email exchange. So what is important for this case is even when the parties were negotiating via email, there was no caveat, no indication that it was to be subject to contract. The second important point to note is both parties are already in agreement on the terms of the contract. So there's no dispute as to what the terms were. The only issue for decision here is that whether having agreed to the terms, which includes a provision that it is not legally binding until it is signed, then when does a contract actually comes into being? When is it actually formed? And the court here decided that it is formed when both parties have signed in accordance with what the contract expressly provided for. Well, the one point which the court did not address at length, but there were some indications from obiter from the court that had this been the very first transactions between the parties, the outcome might be different. It is the fact that this is the fourth transaction and all the four transactions are on the same terms and the same modus operandi operated very strongly in the minds of the Court of Appeal. And the other point to note about this case is the legal principles were not in dispute. In fact, I think it is quite clear, quite trite law on what the legal principles were. What the court did here is really apply the very specific facts of this case to the legal principles. And it was prefaced by the Court of Appeal at the start of the judgment that the finding of when the contract is legally binding, when is it formed, is a very fact-specific exercise. So it requires the court to go into very minute details of the facts to ascertain what the parties' intentions were. And also, the court made it very, very clear that the party's intention, in this case, is not their subjective intention. It is the objective intention as can be inferred from the conduct and from the words used and from the terms of the contract which the parties have agreed to. So this is not to say that every case where you do not sign, you will not be bound. No, there are cases where if you do not sign, you will still be bound. But it's possible if in a correct situation, based on the facts that even though you may have agreed on the terms of the contract via email, that so-called agreement may not be legally binding until something else happens. For example, the signing of a contract. I think that concludes my presentation on this case. Thank you all very much for your attention.
Thank you, Joseph, for presenting it in a very compact manner. And so now I'll pass on to Elaine Yee, who will present the commercial perspective of this case. Over to you, Elaine.
Thank you. Can you see the PPT?
Yes, yeah, good, Elaine.
Okay. So thanks for Joseph's impressive presentation. Now kindly allow me to take over and share some thoughts from commercial point of view. Hope it could be helpful. So commercially, to help avoid contractual dispute, it is highly recommended that the base contract or working CP should always be carefully reviewed after fixing, preferably before execution of contract or in shipping before commencement of actual voyage. During this contract reviewing process, today I would like to share three kinds of situations where clauses need to be paid extra attention. One situation would be that any clause in conflict with the agreement previously done by email exchange, they should be removed or logically amended to ensure consistency. Otherwise, it could become disputable later on when one is considered as accepted to new terms by agreeing to the wording of contract latterly drafted. Take the shipping contract, for example. If in the main term, it says the prepayment should be done within 5 days after bill of lading issued and released, while the base contract says first the freight payment should be done within 5 banking days. So this kind of contradiction could be easily logically amended when you do the CP review. Second situation would be that any clause giving additional explanation, condition, or exclusion, which was not the intention. This information, though only existing in base contract, might be treated as supplementary explanation, thus constitute part of the full contract as well. So if the counterparty has no intention of getting bound by same, they should make sure same clauses removed from contract as well. For example, recap say, notice of readiness can be tendered upon arrival at the port, whether in anchorage or not, whether in berth or not, whether customs cleared or not, whether in free practice or not, which is very common. But the base CP say, if the berth is not occupied upon vessel arrival at the port, then an OR should be tendered upon arrival at the berth. This is a typical example of express exclusion to main terms. Take another example. In the recap, for a forward voyage, for example, about the vessel nomination. It mentions vessel nominated must be geared bulker with 4 cranes of 30 metric tons, grabber or non-grabber, not older than 20 years, etc., like airway, beam restriction, whatever. But base CP say, in case vessel nominated is older than 15 years, then vessel owner should pay charterers $50 per metric ton as additional premium on cargo insurance. Same costs can be deducted from freight without presentation of vouchers from charterers. So this kind of supplementary explanation or condition can be easily overlooked. That's why it is important. You have to look into the details of the base contract. So within the 20 years vessel age limit, there's additional conditions specifically for vessel aged between 15 years to 20 years. In case owner overlooks that, their shipping cost could be much higher, and the vessel nominated, if the vessel nominated is over 15 years old. Let's take a look at the last situation we would like to introduce today, which is also what we see in the case of Avra versus CCS. There is a clause in the contract which specifies the condition for the contract to validate or become binding by signing. The intention of such clause is to provide one or both parties a break to make the contract legally void, which could be dangerous for the party who wait for the contract to be fully executed without fail. In Avra's case, clause 26 say, this agreement shall only come into force after being signed by both buyers and seller. To prevent a similar situation in our daily work, one good solution could be to incorporate one CP administration clause in the main terms, which is also a common practice in shipping to cut the connection between CP signing and the validity of CP. Today, we bring an example of clause 31 in Gas Void 2005 for your reference. So in this clause, it says, this clause is optional and shall only apply when the parties have specifically agreed in the fixing confirmation in the form of party 1 or similar document. The charter party terms and conditions are evidenced by the fixing confirmation, which shall include the negotiated terms in full and all amendments, additions, and deletions, if any, to Gas Void 2005, sent by the brokers and approved by the parties. Such approval shall be confirmed in writing by return to the brokers. The broker shall then confirm receipt of said confirmation to both parties promptly in writing. The last one is most important. Accepted as requested in writing by either the owners or charterers. There shall be no formal written or signed charter party. In the end, I would just like to emphasize that to review the contract wording after deal is done, preferably prior to commencement of contract execution, is of utmost significance. Meanwhile, it should be noted that the standard form template generally favors the contract drafter and may sometimes contain contract trap. So the recipient should never underestimate clauses in the standard form template. Blindly accepting same without thorough understanding every clause could lead to disadvantage to them in the end. That's all from me today. I know there are many lawyers today. So in case you find above mentioned not that rigorous from legal perspective, please bear with me, and you are more than welcome to join our discussion, share your opinions in the chat window or in our Q&A session. Thank you.
Thank you. You did a great job. You offered the problems and also the very practical and commercial solutions which come with it. Yes, especially your closing remarks on a contract trap. Yeah, that was very interesting. Thanks for that.
Thank you.
So yeah, our institute logo, and on the bottom is our word, our bond, and those 4 words have a tremendous amount of significance. This chartering business started more than 100 years ago, when the institute was formed, and back then there was no emails and no telex, and also when the business was done verbally, that is where this motto came in, our word, our bond, where both sides were expected to honor what they said. So I too feel that the final step of signing is not really that significant. What happened before that is really the intention of both parties who are discussing the contract. So with that, I will open the floor to other questions. There's one question pending. I think this refers to the last case. Maybe while the others come in, we could handle this. This is from Mr. Yape, and probably it's addressed to Lakshmi. He didn't mention the name. So the question reads, hi, if checking the cargo is important, why didn't the captain do the inspection in the first place? There are a lot of complications in this. Maybe I'll Lakshmi, if you're there, you want to answer it?
Yeah, sure, Captain. So sometimes, though, especially soybean, for that instance, master could have done a very good job of inspecting the cargo, and the cargo could still be damaged at the discharge port. So that is just for the soybean as such. But in this particular case, if the question is, why didn't the master inspect? So we do not know very specifically what the master did or didn't do. The master has just said it's been clean on board. The master inspected and then provided it as clean on board, or he didn't. That is not very clearly stated in the facts of the case. But practically, if you see, well, when you're loading soybean, right, it's quite dusty. The cargo could be quite dusty, and if you're loading at a very high rate, then the cargo may not be apparent. The conditions of, or the inherent vice, let's say, it's just about to be moldy. That may not be apparent while loading. And soybean is one cargo where you say it's not a dangerous or a very what do I say? It's not a dangerous cargo as such, but the cargo is to some extent not a very stable cargo. At particular temperatures, this cargo with no external factors can just get moldy by itself at just at the right temperatures and the right moisture content. And once it gets moldy, then this mold, it deteriorates the cargo. It self-heats the cargo, and this self-heat of the cargo itself burns the cargo. So without any external factors, the cargo in the hold is just burnt by itself. And at the discharge port, you just open, you have a big surprise, right? You open the hole, the cargo on top looks apparently good, and as you're discharging, you see that the cargo is burnt. And this case also, they say that the cargo is burnt after the cargo that was burnt, like seemed burnt, was like after discharging a part of the cargo, and it's not on the top of the cargo. It's just after discharging some cargo. Some in the middle, they have seen that some cargo is burnt, and it's related to hole number 3 and 5. So the cargo could be damaged while the cargo is on the way, on the passage, for a long passage, that is from Brazil to China. And apart from the inherent nature of the cargo itself, the conditions of the hold, there's little moisture in the hold, or the condensation that is happening from the holes, from the underside of the holes, or you can also say that the holes are just into bunker tanks. The heat from the bunker tanks, those are also the other aspects that could affect and damage the cargo. So yes, master could have inspected very well, and the cargo could still have been damaged. That is also a point in this case. Hope that answers your question.
Yeah. Thank you, Lakshmi. Yes, that was a detailed answer. Yeah, no, I think it's not practical, especially soybean. The stack is quite some distance from the ship. It may not be near the ship. It comes by closed conveyor. Today, especially in COVID, I don't think any crew is allowed to even step ashore, leave alone inspection. So yeah, while on paper that looks right, it may not be possible in practice.
Sorry. Can I just also add a short answer to that?
Please.
I think the short answer is also the master is not a cargo expert, right?
Mm-hmm.
The master is a guy who sails a ship from A to B with cargo on board. And the ship owner's job is to sail the cargo from A to B with the cargo, and it is to deliver the cargo in the same state that it was loaded. Right, so the master just looks at the cargo when loaded and says, "Yeah, it's in apparent good order and condition," and away we go. Right, the actual state of the cargo is an issue between the shipper and the receiver. Right, and in this particular case, the ship owner would actually have had a defense under English law because the cargo was pre-shipment damage to the cargo. Right. And that was the Chinese court got the decision wrong, actually. But I think that's a short answer to the question is the master just isn't an expert on cargo. So he sails the ships and just gives that cursory sort of, this is what meets the eye kind of assessment.
Sorry, if I could just also add, I have considerable sympathy for masters. They come under incredible pressure not to issue clean bills of lading. And sometimes the pressure is enormous, and the master's really on his own, depending where the port is. Maybe he's got the help of P&I consultants. But apparent good order and condition really means nothing. Insofar as a container is concerned, it just means the container looks in apparent good order and condition. It's given rise to a number of legal questions, but I just don't understand how a master can be taken to have warranted the condition of a soybean bulk cargo that's put on board with evacuator, with dust, heat, at night. It's just ridiculous. I can see Stefan's nodding. Thank you, Stefan.
Thank you, Paul. Yes, I think that's true. Yeah, I in practice and having sailed as a master many years back, I don't think this responsibility should be passed on to the master. We have one more question before we go from Mr. Rahman. I have never seen that brokers or charterers send the CP recap, etc., for checking by the lawyers. Is there any instance? I'm not sure who this is addressed to, but no, I don't believe a lawyer CP recaps are sent to the lawyers unless there's an incident, after which, yes, everything is sent to the lawyers.
Well, sometimes I've seen a couple of instances where owners have wanted to go into long-term business, for example, and they want to make sure the contract is in order before they sign off, or they want to go into new types of business, then they want to get a lawyer's input. I've seen a couple of instances of that, but the guy asking the question is right. It doesn't happen very often. I think normally people like Elaine would be, able to sort everything out.
Yes, I agree there as well, typically. But you're right. If it's a complex business or something, then yeah, it's good to get the lawyers to view. Okay, that's no more questions for now. So we'll go on to the third case, which is Regal Seas Maritime versus Aldendorf. And presenting the legal aspect is Mr. Paul Ashton from HFW. Over to you, Paul.
Is my screen shared?
Yes, we can see it. Good. Mm-hmm.
Don't think that is actually. I'm sharing the wrong document. Forgive me.
Yeah, no, that's.
It's right. It's right, Paul.
It's right. Yeah.
It should have my face in water to start with. Is that right?
Yes. Yeah.
You can see your face in the water, Paul.
Yes, thank you. Unfortunately, I've opened up a Word document. I'm going to close that down. Well, I can't actually see it, but can you just to confirm the next slide that I'm going to put on, does that have the orange hire clause?
Yes, that's right.
Thank you. All right. Sorry about that. Great pleasure to be here. Thank you all for your patience. Some excellent presentations. They've set the bar very, very high. This case, Regal Seas and Aldendorf, if ever there was a case to be co-presenting with a broker, And in particular, in my case, Anu is a fellow of the Chartered Institute of Brokers. This is the case because the facts are very dense, and lawyers like me don't really understand the workings of the Baltics, let alone the Baltic Cape Size Index. So I'm very, very pleased to be doing a bit of a tag team here with Anu. So I'm going to just say not too much more, pass you over to Anu, who's going to explain the Baltic indexes and why they're relevant to this case. I'm going to jump back in, tell you a bit about the parties' positions, tell you what the judge decided. In my view, he got it right. And then Anu is going to have some more discussion about the Baltic and maybe how to stop these problems happening. And finally, I'm going to say a few words about two legal matters which were very important in this case. Basically, advice and summary, excellent summary on the construction interpretation of contracts. And secondly, implied terms, which again is something that Stefan talked about and crops up quite a lot. Mine in a slightly different context, namely how you use implied terms to aid in the construction of contracts. So could I please pass over to Anu? Hello, Anu.
Hi. Hi, Paul. Thank you so much. And good afternoon, ladies and gents. So, so we begin with some background on why it happened, what happened, and hopefully give some suggestions on how to possibly avert this or similar situations in the future. I'll start sharing my screen. I think, Paul, you'll have to stop sharing, then I can start my slides. Okay, so my take on what caused it. Well, maybe Baltic Exchange was born with so much of peace and quiet and harmony in the picture and thought, how do I shake things up? But seriously, if we look around, shipping has been the most dynamic industry in the past 10 to 15 years, with in markets, out markets, vessel sizes, specifications, bunker parameters, world politics changing constantly, and the shipping doing its best to work around these challenges. Our current case deals with the charter done for a 179,000 tons deadweight Cape vessel for an initial period of 3 years plus 2 years in charter's option, which was concluded on the 22nd of November 2013. The price was linked to the average of 4 Baltic Cape-sized TC routes. Now, the Baltic-sized vessels being 172,000 deadweight, hence a size adjustment was agreed at plus 4% over the index numbers. So charters exercised the option to extend the charter for 2 more years in 2015. However, on the 31st of July 2015, Baltic decided to have its share of fun and changed the benchmarked vessel itself to now 180,000 deadweight with a 5 TC average route. This was bigger and better than the chartered vessel. Although simultaneously, the old index, which was based on 172K, was also published, but it was not assessed anymore by the Baltic. It was only published. It was merely a shadow of the 180K DWT. So initially, as we can see in the data below, highlighted basis the time spans. There was probably an attempt to calculate the real time differentials, and hence, if you see at the end, the differential per day is different over the days. But as we enter 2017, they simplified this formula. So probably they would have gone for one-time calculation, figured out a one-time TC differential in dollars, and that became the constant dollar differential basis. That means thereafter, no matter where the market goes up or down, wherever, the difference between these two sizes, the time charter difference between these two sizes was going to stay the same, irrespective. So this shadowing also came to a halt by end of 2017. whereafter only 180K DWT index was published. So this is the background, and now that we have a commercial picture all set up and the explanation of how the index is worked, we shall move on to the legal aspect of the situation and how the drama unfolded. So on to Paul.
Thank you very much, Anu. I'm very grateful for that. I'm going to share my screen again. Is that shared? Apparently I'm screen.
Yeah, it's there. Yeah.
Brilliant.
It's your opening screen now, and
yeah, thanks, Doug. Okay, the first thing I want you to focus on is the specific hire clause, and you'll see that the gross daily hire was to be calculated on the basis of the 4 time charter routes published by the Baltic. The important point here is over the previous 15 days plus 4% for adjustment. Now, why the 4% adjustment? The 4% adjustment was because you can see that they were using up to July 15. The charter was a 2014 charter. You can see that the actual vessel was 179,258 tons, so very nearly 18000. So clearly it was larger than the 172 benchmark, and the parties quite reasonably decided and negotiated a 4% uplift. But that was meant to be continual as the rate varied. There was an addendum to the charter in 2007 where effectively they continued to adopt the same hire. So I can fortunately miss quite a few of these slides because of what Anu's told me. Now, the owner's position was very straightforward. They just said, looking at that hire clause, that from August 2015, hire should have been based on the 180 rate, because there was no 172 rate anymore, plus they get their additional 4%. Well, that was great from the owner's point of view because they're getting a higher benchmark rate plus 4%. They realized that represented a windfall, so they put forward their alternative position. And it's fair to say that they pushed this much harder and it found attraction with the judge. Namely, what they said is that because of the switch from 172 to 180 benchmark, that you have to then imply that there should be a reasonable size adjustment, because obviously the previous adjustment would make a windfall. And given that this vessel was very nearly the same size as 180, then in that case, just on size, comparison on size, there's other things that go into the benchmark, that clearly it should be nil. The charterers didn't like that. Their case was that the parties intended that the base rate would be at the base rate of 172,000 for all the life of the charter. The 4% uplift was fixed. It couldn't be messed with, and it must be fixed to the 172 benchmark throughout the life of the charter. Ergo, to the extent that the rate for the 172 vessel continued to be published by the Baltic, the parties must have been intended to adopt that rate. A couple of things rather unsatisfactory with the charterer's case was, and inconvenient for them, that as Anu has said, what they actually published, the Baltic, was a fixed shadow rate, and it didn't certainly comply with the original clause. And secondly, unfortunately for the charterers, the clause said, as the judge went on to find, that the most important thing was there was no longer the ability to benchmark against the 172,000 tons over the previous 15 days. Here, the big problem was, of course, that the parties did not consider what would happen if the benchmark changed over the course of the charter. Now, that may have been understandable where you have a one-year charter. And in fairness to the parties, and I feel sympathy for them, the 172 benchmark had been there since 2004, and it only got changed in 2015. So you can understand why perhaps they didn't look at it, but this brought about what I call a gap in the contract, or what I'll later refer to as the trap gap. Now, the judge, Mr. Justice Tier, gave his judgment in April, probably one of his last judgments because he's recently retired from the bench, an excellent judge, senior judge of the Commercial Court, and he knocked out numerous judgments in his stints, 2 of them for me, one of which was against, one of which was for. Never mind, that's another story. He said, I consider that the difficulties facing the Charter's constructions are formidable. They can only be overcome by reading the reference to an average rate published by the Baltic as encompassing what the Baltic itself described as a daily rate for the 172.40C derived from the 180.40C, later the 185.TC, as from 17, at a constant dollar differential. And the problem with that is, again, I've given you the hire clause. You can see that that construction is just far too strained, and there's no way you can reasonably, as a matter of construction, fit Charterers' arguments into what the parties had agreed. Now, this is very interesting because the judge said that the Charterers' position amounted to a rewriting of the hire provision. And I won't stress the point, but essentially he also relied upon Charterers' own counsel's argument. Charterers' counsel, somewhat contradictorily, described the rate capable of being calculated after July 15, that is when there was no longer an active 172 benchmark, as an official rate endorsed by the Baltic. But unfortunately for them, the judge was having none of it. What the judge said was that wasn't what the parties had agreed. Now, the judge accused the Charterers' argument as being one in which they rewrote the contract. But he then rewrote the contract by adopting the owner's alternative case, which was to imply a term. And he did that on the basis that clearly the 4% adjustment at the beginning of the charter was warranted in order to reflect the advantage to the Charterers of this vessel's actual size and characteristics, as opposed to 172,000, because it was nearly 180,000. However, he said that they do not, the clause doesn't allow for any adjustment other than 4. It is fixed, and in that respect, he agrees with Charterers. But the way you get around that is to hold that there's going to be an unfairness, there's going to be a windfall. And actually, the court's job is to try and keep contracts alive, try and keep them in existence. And to do that, it's justifiable to imply a term. And the term is that, the implied term is that the appropriate size adjustment in the event of a change to the size of the benchmark vessel was intended to be a reasonable adjustment. So he says, if the benchmark changes from 172 to 180, then you've got to change, and there's nothing in the contract which says what you do with the adjustment, then you have to change by making a reasonable adjustment, and you can imply a term to that effect. And that is not rewriting the contract, that is a justifiable method of construction by implying a term. You can see that one could be confused for thinking that it was rewriting the contract. I don't. I think he got it absolutely right, because I'm a fan of implied terms. Whenever you've got nothing else to argue, you can always argue implied terms. Now, this situation arose because of the gap trap, and that's just a warning to parties. Please try and consider what things could change during the duration of your charter. And as for the implied term, it was justified on one of the bases which Stefan mentioned. It gave what we call business efficacy, or rather commercial or practical adherence. And finally, what I would say here is there was an old case, well, not so old now, well, 20 years ago, Mamadou case, where the excellent Lord Justice Rick said, particularly in the case of contracts for future performance over period, where the parties may desire or need to leave matters to be adjusted in the working out of their contract, the courts will assist the parties to do so, so as to preserve rather than destroy bargains, on the basis that what can be made certain is itself certain. And there's the nice Latin phrase as well. So I will say a little bit more just about what is correct, well, summarize where we are on construction and implied terms, but I'm now going to invite Anu to come back in and baffle us all with more about the Baltic.
Anu, you're mute. You're mute, Anu. You're still mute.
Huh?
Yeah, now.
Okay.
Yeah, okay now.
Right. So I can share my screen. Okay. So now that we know what happened behind and in front of the curtains, we have attempted to see commercially what could be done in future to at least minimize a recurrence. So take home for today would be that, you know, in future we could be linking the charter parties to index. See, linking of charter parties to charter hires to index has not been a very unheard of, or it's not an unusual thought process. Similar concepts are seen in, say, a bunker adjustment factor, or for example, open book calculations for change of port, where the adjustments are left for future on subject to changing parameters. So it would be a good idea to have a base calculation agreed to, which would set a logic to the understanding, allowing any change in any of the parameters going forward to show an equivalent result. So for example, I'll show you a calculation sheet in the next slide, which shows the routes and the average index calculated on an index vessel parameter, which is a 180K, and the intended vessel for charters, that means a time charter or a period vessel. So going forward, any change in the description should maintain the initial link of logic as was originally intended. So that means whether the size changes or the bunker price changes, or any or the speed consumption changes,
Sorry, Anu,
any parameters changing would give a result which we have initially already agreed to. Now this comes with a disclaimer. This is something which is specific to our company, and it is customized for NetBulk. But this could be something that that could be used by by companies, and maybe this could work for them. So I'll just share with
Anu,
you.
can you just put this on a slide view or the presentation view, because
Like
it's
this? Yeah.
yeah. Thanks.
All okay. Can see now, Puneet?
Yeah, much better.
Okay. All right. Okay. So here we can see these are all interchangeable interactive data which is displayed here. On the top, if you notice, it shows how a Baltic 180K looks like, what the standard speed consumptions and size and TPC, etc. of the vessel is. And if you see below, it's an intended chartered vessel, which is Shine On, and the specifications of that particular vessel. Now, this is benchmark, or this is tested against various routes, which are again, most of the routes you would see are as per the index routes already published by the Baltic, and some of them are specific to us. So that means as NetBulk, when we are evaluating, those routes matter to us. So we have given a certain calculation out here, and the point to be noted is at the end, we can see a one-on-one differential between the routes and the indexed vessel versus the time chartered vessel. And you could see whether it performs better or lesser, and you could also test if the parameters change, that means if the indexes drop, how does it affect, those kind of things could be pre-decided. So it takes away a lot of ambiguity in what was the concept you had fixed your vessel at. And going forward, if both of you have managed to agree to a certain base calculation, this can become the Bible. Anything changing, you can always fall back on that. So points to be remembered is when the charter hire moves, the resultant differentials do not necessarily move with same gap. So hence, Along with agreeing to a base calculation, which we saw in the last slide, it should also be agreed as to when the changeover data is to be applied. That is, the charter hires or the relevant values, whatever is changing, which is to be taken, should be those of the original charter date or the changeover date. So that's something which we suggest should also be pre-agreed. So in case of any other unforeseen situations, I mean, you can't think through everything, the contract should allow for a mutual discussion or an agreement before the charter continues or extends or maybe collapses. So shipping industry is still evolving, as we all know, using economies of scale. For example, Ultramaxes and Newcastle Maxes are already a known size segment, performs variant to the published indexes. So going forward, I mean, this could happen all over again. A Baltic index may change all over again. So more the clarity, easier is the life, because the only constant we know is the change. And over to you, Paul.
Thank you very much. Anu, I think we do a great tag team. If ever I got to wrestle and tag, I'll have you with me, because this is great. Just a few things background I wanted to say about this case, rather than looking at no more death by PowerPoint for me. Just a summary. First of all, it was Dimitri Vassos in my Greece office, a very good partner there, who head of our office, who handled the case. I should say that it is that there were two other defences raised by the charterers, namely that the owners had agreed a variation by conduct, and or that they were stopped from denying the charter rate that they had paid was the correct charter rate. I'm not going to say anything about that. We don't have time, and I don't know enough. I can see that those could be very interesting arguments. So the matter has been remitted back to the arbitrators, because the arbitrators felt they didn't need to determine those two issues, because they had found for the charterers, and therefore there was no point in dealing with them. So that is going to be referred back to the arbitrators. So it's not the end of the matter. It is the end of the matter on this point, though. Secondly, leave to appeal was given under Section 69, where there is a clear error of law in the English Arbitration Act. I mention that because I know it's been debated at the SCMA in talks and elsewhere, whether or not we should have a limited right of appeal in Singapore. I think the better view is that we should, that the argument that it opens the floodgates for everybody to appeal is not the case. I think Sir Bernard Eder was before the SCMA and has said in a very good article and also presentation that these are applications which are made on paper. Only 12% of them are ever given leave to appeal. And of those 12%, only 3 or 4% actually succeed. So this case was actually one of those 3 or 4%. So I think, you know, when an arbitrator gets it wrong in law, I think it is nice. Well, I just think, even though you want certainty, you don't want additional costs. I think sometimes it is nice to have that additional right of appeal. I should also say, in fairness to the arbitrators, Mr. Justice Tier, who had the benefit of full argument, unlike the judge who just allowed the leave to appeal, on hearing the appeal, Mr. Justice Tier said that it was a difficult matter of construction. And although he disagreed and said that the arbitrators got it wrong in law, he had some sympathy for them. I think what I'd like to bring to your attention is that construction of contracts has given rise to a lot of law. There's a wonderful book called McMeel on the construction of contracts, and in there they list 12 Supreme Court and Court of Appeal decisions just in the recent past where the law has been evolving. The lawyers amongst us will know that in the old days, construction used to be the word of the contract was sacrosanct, the literal interpretation. Read it almost as though what it says is absolutely true without context. The courts have edged both in Singapore and in most Anglo-Saxon jurisdictions to a more purposeful or purpose-driven interpretation. This has often been called the battle between textualism and contextualism. And I think the English law, and certainly in Singapore, we've reached a really good balance, which accommodates common sense, assists the parties, but doesn't go over the top and actually rewrite contracts for people, because sometimes at the end of the day, the contract is the contract that the parties negotiated. And I just wanted to quote one or two little comments from the cases. Now, the judge in this case, which is why I commend it to you, did summarize the position at law very well and went through the authorities. And he said, interpretation is, as Lord Clark stated in the Rainy Sky, a recent case, a unitary exercise where there are rival meanings. The court can give weight to the implication of rival constructions by reaching a view as to which construction is more consistent with business common sense. But in striking a balance between the indications given by the language and the implications of competing constructions, the court must consider the quality of the drafting of the clause. He said, and I love this because it's so poetic, textualism and contextualism are not conflicting paradigms in the battle for exclusive occupation of the field of contractual interpretation. Well, it's beautiful, but what does it mean? Some agreements may successfully be interpreted principally by textual analysis. For example, because of their sophistication and complexity, and because they have been negotiated and prepared with the assistance of skilled professionals. The correct interpretation of other contracts may be achieved by greater emphasis on the factual matrix, for example, because of their informality, brevity, or absence of skilled professional assistance. Now, he went on to talk about what happens if there's clearly been a mistake. But it is clear that something has to have been wrong with the language. In such circumstances, the court can interpret the agreement in the contract and the context to get as close as possible to the meaning which the parties intended. However, he said that there were limitations to that, and the correct statement of law is, first, there must have been a clear mistake in the language or syntax in the contract as distinct from the bargain itself. And secondly, the court can only adopt this approach if it is clear what the correction should be. Above all, the intention is to ensure that the contract should continue rather than fail. And in addition, if a clause is capable of more than two interpretations, always go for the one which makes the best common sense. That's one of the reasons why I'd commend reading the clause, the case. The other is that it has a really splendid summary also on implied terms. And it's interesting, isn't it, that both Stefan's case and mine deal with implied terms. Implied terms is a huge area of evolution at the moment, maybe a subject on a future date. But for example, English law is making quite controversial steps. I'm all in favor of it, but some lawyers aren't, in saying when and when you cannot imply an obligation to conduct your obligations, contractual obligations, in good faith, and they have developed what we call relational contracts as opposed to non-relational contracts. I think this is a really interesting case which shows how knowledge of the market and the industry is absolutely essential for both lawyers and everybody involved in it. And it's been an absolute delight to be able to present it with such an experienced shipbroker and charterer. Thank you.
Yes, thank you, Paul. That was very interesting, particularly your reference to common sense. I was just thinking, what are the first three alphabets of commercial, COM, and what are the first three alphabets of common sense, also COM? So commercial perspectives generally tend to be more aligned with common sense. Yeah, and particularly your tag show was very good. I mean, those of you who understand Hindi, it's also known as Jugalbandi. So that was very interesting, and I think the audience must have found the explanation very lucid. The only development I see is BIMCO stepping in if this is likely to happen again. So you might have a BIMCO clause dealing with changes in index. So I open that. I don't see any other questions from the audience. If there's anybody, your last chance before I pass it to Mr. Punit. Or anybody in the panelists, would you like to comment across the cases? And okay, then maybe I'll thank everybody. Thank you, panelists, and particularly thank you, the ICS panelists. Yes, and the ladies. It was a great idea, and thank you for putting a great show together. So thank you all, and I'll hand you back to Mr. Punit. Over to you, Punit. Thank you.
Thank you so much, Captain Dutt. Thank you so much for this extremely useful webinar. First and foremost, we would love to hear from you. Can I request all of you to fill out a post-webinar survey form? I'll just share a QR code, and you can please try and either scan this and send it out. I'm also putting the link for the QR code on the chat box in a minute, so you guys can actually use that function. Let me just do that. Just give me 1 minute. Just be able to quickly put it on my chat box. Oh. To all panelists and attendees. Perfect. So obviously we would love to hear from you. The chat box has the link to the form. It's a very simple post-webinar survey form, and you can fill it up. I would like to address the current audience, but also the future audience and viewers who will hopefully be seeing these discussions in future on the SCMA YouTube channel, where all these webinars are stored for future reference. Every time I attend an event like this, I'm amazed at the reservoir of knowledge which sits within this industry. And I'm also acutely aware of the lack of standardized means to disseminate this knowledge so that maritime professionals can be better equipped to make smarter and knowledgeable decisions. All the technology in the world cannot replace the final decision maker, you, who will, using modern data and information and analytics, finally take that call to put the right clause in the contract due to a piece of information that you have retained in your brain out of such a webinar as this one. That is a fervent wish of both our organizations. I'm extremely privileged that I'm involved with both the organizations hosting this event. And I thank the Institute of Chartered Shipbrokers Singapore branch for their continued support in hosting the second event in this legal and commercial perspectives series. I'm sure this will become a lasting series as both organizations hope for. Maritime industry and maritime arbitration are unique in many respects. In recent Queen Mary White and Case survey on international arbitration 2021, where it's a matter of great pride that for the first time Singapore was jointly ranked as a top choice for international arbitration along with London, one of the respondents said that in maritime arbitration, parties want a dispute resolution mechanism that was developed by their sector, for their sector, and conducted by practitioners from their sector. LMA has developed along these lines over many years and led the way. And SCMA is providing such a mechanism, especially as it sits right at the heart of Asia, and its arbitrators understand Asia and the way it works. This event today, similar to all the events hosted by SCMA, have been hosted by the industry, for the industry, and with the support of industry practitioners. Thank you all for attending and participating in the webinar today. Before I thank the panelists, I would like to thank Vinny from my team at SCMA Secretariat, Lei from ICS Singapore Secretariat for all their hard work in putting the event together. I would also like to thank all the speakers and the contributors for their efforts and support. Thanks, Bengti, for opening remarks, Captain Dutt for moderating the event, Stephen Pedersen, Joseph Tan, and Paul Aston, all our panel arbitrators, I'm proud to say, for distilling complex legal issues into simple slides. And finally, an all-female commercial cast of industry professionals in Elaine, Priya, and Anupama for the practical sharing. It's truly a small world, and I must mention this, As I see Anupma presenting today, I've known her since my school days in Mumbai. It's so great to see her presenting. Connections and networks are the lifeline of this industry. I would like to end this event with a thank you note to this amazing industry, which never gets due credit for all it does for the world, and its real heroes, the seafarers, who are still not given the importance and respect they truly deserve. In fact, even when the industry gets coverage, it's usually negative. While we do our best to reduce accidents and emissions, it must be remembered that shipping is the most cost-effective and energy-efficient way to safely transport goods across the world. As a gesture to thank this amazing industry we are all in, both ICS and SCMA have decided to end this event with a simple but impactful 2-minute video from our partner organization, BIMCO, Ships Make the World Go. Let me just share that. It's just a 2-minute video. Can you hear it?
World stopped. Ships kept moving. Ships kept on moving. By sea, 90% of trade actually. Cars that are sprayed, and it's easy to see the impact this makes. Fruit and vegetables, toys and collectibles, wheats and grains, the blood in the veins. Like to land, a farmer is.
Sorry.
Ships are to the sea, and if the world is the heart, ships are the arteries. We stock the pharmacies with essential commodities. So there's a lot at stake across these seas. Without these routes, half the world would starve, while the other half. These bright-coloured containers, the four walls of our house that contain us, would be empty. No oil, no cars, no essential spare parts. The sea's version of stars, those flickering lights on the horizon, by moon and by sun, but the journey is never done. As a supertanker moves, equivalent to 3 times around this earth. And we are served by over 61,000 ships. The things we buy, the things that shops sell, the 1.7 million seafarers, it's more than just engines that propel this industry. And it's easy to see that a lot is owed to the people that load. 6,000 ports worldwide, but it's not all plain sailing. It's rough seas and piracy warnings and the change that this inevitably causes. The sea covers 70% of our planet, so you can see why we need to plan it. A global community of knowledge and passion, from salt and sugar to the latest fashion. Our ships keep moving products we love using. Ships make the world go. They are very well. And their business grow.
Thank you so much. This was a very useful presentation, and this was an amazing webinar. Thank you so much for everybody. Please stay safe, keep the faith, keep the positivity, and use the knowledge that you have gathered to take the decisions. Thank you.
Thank you. Thank you, Pandit, for organizing this. Bye.
Thank you, everyone.
Bye.